So today's topic is one of the burning topic which we have read in the newspaper that one of the judge house in of Delhi High Court was trapped in the fire. Fire brigade was called to put out the fire, and thereafter what happened that burned currency notes were recovered from the house of the judge, which has led to controversy. And now there is a renewed demand by the opposition that it is high time to evolve the collegium system and we should enact NJAC. NJAC means National Judicial Appointment Commission. National Judicial Appointment Commission. So first of all, we'll have a look at the presentation and thereafter we will discuss the whole issue again. So this is what we are discussing today, that is National Judicial Appointment Commission and Collegium system in light of the incident which has happened in Delhi. Almost it is now 2 weeks. Fire broke out in the house of Delhi High Court judge. So it is regarding the probability of the Delhi High Court judges or the Supreme Court judges or the High Court judges of the any high court of the country, that there should be transparency, there should be accountability, and their appointments as well as transfers should be regulated. So what had happened that in 2014, Parliament had passed 99th Amendment. The bill was NJAC Appointment Commission Bill in 2014. This act was passed by the Parliament and this act was ratified by 16 assemblies, means 16 state assemblies, Vidhan Sabhas of the state also rectified it, and it was assented by President in December 2014. It was assented by President in December 2014. Now what happened? In October 15, this bill was struck down or quashed by Supreme Court that this bill is null and void, unconstitutional. According to the Supreme Court at that time, October 15, this bill was declared as unconstitutional, null and void, and they said that it hinders, impedes independence of the judiciary, hinders or impedes the independence of judiciary. So NJAC, which was meant for the appointment of High Court and Supreme Court judges, for regulations of transfer of the High Court and Supreme Court judges, and for investigation of the matters related to High Court and Supreme Court judges, was declared null and void by Supreme Court in October 15. So what is the present system? Now question is, what is the present system? The present system is for last 3 decades, we are selecting appointments or appointing judges of High Court and Supreme Court by collegium system. By collegium system. So what is collegium system? In collegium system, senior most judges make appointment to judiciary in High Courts and Supreme Court. In Supreme Court, there are 5 members, which includes Chief Justice of India and 4 senior most judges. So any judge of High Court is to be appointed. Then Chief Justice of any judge of Supreme Court is to be appointed. Chief Justice of India of Supreme Court and senior most 4 judges of the Supreme Court will hold a collegium and they will appoint the judges. In case of High Court, CJI of High Court and 2 senior most judges. In case of High Court, say High Court of Punjab and Haryana, High Court of Allahabad, UP, or High Court of Lucknow, or you can say High Court of Rajasthan. There, the Chief Justice of the same High Court and 2 senior most judges will be nominating the appointment of judge for appointment in the High Court. These names forwarded by Collegium for appointment to High Court and Supreme Court. Now government. Government here means the central government and the state government. In case of Supreme Court, it is central government. In case of High Court, it is state government. These governments can raise objections. But if the same name of the judge for appointment is forwarded by the Collegium to the central government or to the state government, it has to be accepted by the government and order for appointment of High Court judge और मैं आपको थोड़ी देर बाद में कॉल करता हूँ हाई कोर्ट जज और सुप्रीम कोर्ट जज हाई कोर्ट जज और सुप्रीम कोर्ट जज is to be appointed as decided by the collegium. So this is our second slide. Now we come to third slide. NJAC was basically made for regulating appointment of judges, transfer of judges and removal of judges. Transfer of judges and removal of judges. So what is impeachment of judges? By impeachment of judges, how judges can be removed from the chair. Recently, there was a case of Sharad Kumar Yadav in which he had given a statement that Hindustan belongs to Hindu and Hindustan is a country of Sanatan Dharma and the minorities have no right to stay here. So this is a kind of, you can say, misbehavior. Incapacity here means that indulging in malpractices, so that is incapacity. Or there may be other reasons of incapacity. So how impeachment of judges is done? It is done by the parliament. Motion is approved by the presiding officer of the parliament. First of all, then there is a 3-member inquiry. In the present case of High Court Judge of Delhi, High Court, Chief Justice of India, Chief Justice of High Court Punjab, Chief Justice of High Court Himachal Pradesh, and 1 senior judge from High Court of Karnataka are conducting the inquiry into the alleged currency notes which were burnt during the fire at the house of High Court judge. Once the inquiry is completed, then finding is sent to the parliament. By finding, we mean the facts which have been generated by the inquiry that goes to the parliament. Parliament, there the presiding officer calls for a session and present on the day, MPs, all MPs who are present on the particular day, they are asked to vote in favor or against for removal of the judge. And there should be 2/3 majority in favor of removal of the judge or against the removal of the judge. Then this bill is passed in both the houses in the same session of Parliament. Now next question is, by same session means winter session or monsoon session. These are the sessions which are held in the parliament. Same session. Either if the Lok Sabha has passed the bill in monsoon session, the Rajya Sabha must pass the bill for the removal of the judge, for the impeachment of the judge in the same session. But say if the investigation is continuing and judge knows that I have committed omissions and commission and he resigns, what happens if the judge resigns? Then investigation stops. First of all, the investigation, that is inquiry which was being held, that stops. But the judge retains the retirement benefits. Judge will get the retirement benefits, whereas other public servants, by means other public servant means civil services servant or junior grade B servant who are appointed through UPSC or through Staff Selection Commission. They are accountable for their omissions and commission, and they are accountable till retirement. They do not get their retirement benefits. They are subjected to punishment according to the findings of the court, and they are punished accordingly. Now, what happens in the armed forces and the CAPF? By armed forces, I mean Army, Air Force, Navy. By CAPF, we mean BSF, ITBP, SSB, CASF, CRPF. Here, the law is strict. The strictness extends to 6 months. If an investigation has been opened up after the retirement, then up to a period of 6 months from the date of retirement, the individual can be called to the part of investigation, and accordingly after investigation the court can be held, that is the summary trial court which we called in the security forces, and court martial court in the armed forces, that is held, and punishment can be given to the officer or to the men who are subject to this act and rules of the armed forces. So armed forces are strict in this matter, that their person, if he or she has retired, they are answerable for their omissions and commissions for 6 months. So this is in nutshell, we wanted to know about the NJAC and Collegium system. Now we will return back to our article which is related to inquiry, and we will have this, we'll have a reading of it, and thereafter we'll go for the question answer sessions. So this is the article which we are looking at. So now you have a look at this article. I am enlarging the screen. So this is the case of Yashwant Rao Verma. Preliminary inquiry findings responded that no cash was recovered initially from him or from his family member in the storeroom, and they were never shown the sacks of burned currency notes during the fire control operation. Even the Director General of Fire Services initially said that fire brigade did not recover any burned currency notes. But later on, Sanjeev Khanna, who is the Chief Justice of India in Supreme Court, he ordered a 3-member committee as per the procedure. An inquiry into the allegation shall be conducted against Justice Verma, and he has been currently transferred to Allahabad High Court by the Collegium. We have already understood what is Collegium system. We have understood what is Collegium system for the Supreme Court and for the High Court. So this kind of Collegium system was developed. In-house procedure for action against the judges was adopted in 1999 and made public in 2014. So when a complaint is received against a judge of high court, the CJI will decide whether the issue is frivolous or warrants an inquiry. First of all, Chief Justice of India will decide whether the complaint has got certain truth or it is frivolous in nature. Frivolous in nature means it is baseless without any truth. If an inquiry is deemed necessary, judge initial response along with comments of Chief Justice of the concerned high courts are taken on the record. CJI can then form a three-member committee consisting of two Chief Justice from other high courts and one high court judge. So in currently, we have already discussed that one is the Punjab High Court, CJI, Punjab and Haryana High Court, CJI, Himachal High Court, CJI, and Karnataka High Court judge. So, if he or she will resign, in the event of judge unwilling to resign, the President and Prime Minister will be informed of the finding of Parliament to initiate action for removal as per provision of the Constitution. So, we have already discussed, if the judge resigns in between, then investigation stops and he will be given the retirement benefits. Whereas the same is not applicable to other officers who are selected through UPSC or B grade officers who are selected through Staff Selection Commission or Armed Forces of the Union to their officers who are also selected through UPSC. So once the finding goes to the Parliament, we have already read what is the system of the impeachment that I have already discussed. So what are the reforms required? Now question is, what are the reforms required? Means we have to make a balance between the National Judicial Appointment Commission and Collegium system. Collegium system says that to maintain the independence of judiciary, it is very essential that judiciary should not be held accountable for their omissions and commissions. Judiciary should be independent. Whereas NJAC is a system which wants to control the appointment of the judges, transfer of the judges, and inquiries of the judges. So what is happening in the United Kingdom? That is England. In England, there is Judicial Conduct Investigation Office, which is involved in the investigation of allegation of judicial misconduct. So the root cause of the problem here is that in our country, there is opaqueness of the collegium process that is followed for the appointment of judges. By opaqueness means it is not transparent, it is not clear, it is not visible what kind of system is followed in collegium process for selection of the judges. So therefore, NJC bill was passed, which was struck down by the Supreme Court in 2015. However, it does suffer from a lack of accountability and transparency. A broad-based National Judicial Appointment Commission headed by CJI with representatives from various stakeholders, including members of the legislature, lawyer association, academia, may be set up on the line of Judicial Service Commission in South Africa. In South Africa, what is happening? There are a number of stakeholders. Number one, the Chief Justice of the court. Number two, part of the members of the legislature, that is MPs and MLAs, and lawyers, means from the Bar Association of the High Court or Bar Association of the Supreme Court. Lawyers are selected. And the academic person. By academic person, here we mean that those who are teaching law in the universities. Say, for example, National Law University, Bangalore, or any other law college which is in the Punjab University, Department of Law from the Punjab University, or Department of Law from Delhi University. These people are known as academia. So then they are selected, and on the out of these National Judicial Appointment Commission, the judicial services officers are selected. CJI and other senior judges may be provided with a veto to have a final say in the appointment process. Such a setup would make the selection process more transparent and inclusive without compromising independence of the judiciary. So, in order to make the judiciary independent. Now it is high time that we should go for the NJAC or something related similar to the NJC. So recently after this incident, Vice President came into picture, that is Dhankar, and he called a meeting of all the opposition party leaders. He assured them that Parliament is supreme, the Parliament is supreme, there is superiority and sovereignty of the Parliament. Government shall have a clear roadmap, and government will definitely come out with some kind of system for the appointment, transfer, and inquiries of the judges. So this is what I wanted to say. Now questions from your side. Come up with questions. सुमित जी बोलिए, क्वेश्चन बोलिए. Okay, if there is no question, we'll stop it here and then wait for the next online class, which may be in 2 or 3 days. Thank you very much. We'll stop the lecture here. Thank you. Jai Hind.